Good afternoon, everybody. I'm just waiting for people to come into the webinar. We'll get started in a couple of minutes. Okay. Well, people are still coming in, but I will get started. So I am here. I'm Dawn McDonald, and I'm here to talk to you today about both avoiding litigation and best practices for dealing with litigation once you find yourself in it. And we're going to talk about not only if you decide to sue somebody, for example, a unit owner or a developer, but also what to do if you are the defendant. And you could be the property manager or the board, or typically it's both. So I thought I would start out first by explaining the basic law that applies to condominium associations, two fundamental concepts that you need to be aware of and that kind of govern everything that we do. The first is that trustees have a fiduciary duty to the condominium trust. You do not have a duty to unit owners. That's actually law. You have a duty to the condominium trust. And what that means is that everything that you do and all the actions that you take as board members have to be for the good of the trust. The second thing that is fundamental is that the property managers are agents of the condominium trust. That is by statute. It is usually in most of your condominium documents that you have the ability to hire an agent to help you run the property. So property managers are the agents. And what an agent means is that everything that the property managers do has to be at the direction and control of the trustees. So you tell the property managers what to do. The property managers do not tell the board members what to do. Your property managers in general have been managing condominiums for a long time. They have a lot of knowledge. You have to be able to rely on the knowledge and the expertise of your property managers. But at the end of the day, it is up to the board members to make decisions that affect the condominium trust. Lawyers also, like us at MEAB, we are also agents of our clients. And we are experienced professionals that you should be able to rely on in order to make decisions that govern your condominium. Also, your accountants, they're also considered to be agents of the board. So rely on the professionals that you have at your disposal to make decisions and to be informed. Really, what I'm going to talk about, everything I'm going to talk about today comes down to common sense and communication. Which seem pretty basic, but every example I'm going to give you today is a real life, real world example of cases, things that happen in cases that I'm handling, that I've handled in the past and that I'm currently handling, situations that have occurred more than once. And it has gotten to the point where I said I really need to do a webinar about this because our clients just don't know. And even the property managers don't know about some of these things. So, in the context of litigation, let's say the board gets sued by a unit owner. The first thing that you should do when you get a lawsuit is call us and send us the complaint. Okay? You need to not speak to the person who sent you the complaint, who served you with the complaint. Don't talk to the unit owner, and notify your property manager if they weren't the ones who notified you. So typically, a lot of times the property managers will get a complaint and they'll send it to the board and they'll send it to us. But if the trustees get it first, send it to your property manager and send it to us. Another thing regarding the trustee's responsibilities when you get a complaint is that you cannot abdicate your responsibilities to your property manager. You cannot say, I just volunteered for this position, I didn't bargain for a lawsuit, and I'm not dealing with this. You can't do that. You have a fiduciary duty to the trust. If you don't want to be involved, then you need to resign. Because if you're a trustee and the trust gets sued, you're involved. You have to be involved to defend the trust. You should also be having regular meetings with your property manager. And what I would say is a regular meeting is once a month. It doesn't have to be a long meeting, but the trustees should be aware of what's going on in their condominiums. A lot of times, as I said, they abdicate responsibilities to their property managers, and they don't know what's going on in their buildings, and this can lead to problems. It's a very simple matter to just send routine emails. If you're having enforcement issues in your building, for example, have your property manager once a month send you a list of any units that are not complying with the condominium rules and regulations. Again, it's all about communicating. It's very important. And you, because the trustees are responsible ultimately for the acts of your agents and for the condominium trust, the buck stops with you. So you all have to be informed. It's very important. I have many, many, many boards that I've defended over the years that are not involved. They abdicate everything to the property manager, and they're your agent. They answer to you. If you're not providing your property manager with direction, you're going to have problems. So it's very important to be involved and to know what's going on at your property. Property managers also have to make sure that the board is informed about what's going on in the day-to-day operations. So it's of course appropriate. You've hired a property manager so that they can handle your day-to-day functions at your condominium. That's fine. But you have to make sure that the property managers are communicating with you, as I said, and maybe you have a monthly meeting, or even if it's only 20 minutes, or ask them to send you a monthly report. What's going on in the building, any problems that have cropped up. Are you having any issues with enforcement? Are you having any issues with complaints? Is anybody asking for accommodations? That's a big one. And we'll talk more about that in a few minutes. If you're considering suing somebody, one of the things I want to talk about is being judicious in the actions that you take. I'll explain this by way of an example. You all have rules and regulations at your condominium, and the condominium documents and the statute govern how a condominium operates, what the property managers do, and the actions of the board. Nothing about that has changed. Typically, you have broad discretion. Trustees have broad discretion to enforce the rules and regulations of the condominium, and it could be argued that it is your fiduciary duty to enforce the rules and regulations. I'm going to tell you that as time goes by and our society seems to be evolving, you may want to think about whether you are going to enforce the rules and regulations as strictly as you used to. And what I mean by that is, if let's say you have a unit owner, and we've had this, You have a unit owner who's, let's say they're a hoarder, and they've made threats to other residents or board members or the property manager, and you call us and you say, they're violating the rules. We've got rodents. We have he's harassing residents. We have complaints. He's a nuisance. We want you to bring an enforcement action to make him stop. What we're going to say to you is we're going to ask for the facts. And if you tell us that this person has made threats, then we're going to say, do we really have to bring an enforcement action? Is that the best course of action for the condominium as a whole? There was one situation where there was a unit owner who had made threats to shoot people, and we got a call that they wanted to enforce some rule. It wasn't my case, but it was some rule about his parking. And we said, that's probably not the best idea when this guy has been threatening to shoot people at the condominium. So that's what I mean when I say maybe you need to think about whether you're going to file an action to enforce rules. Another example is when you have, there are a lot of dog cases where people have no dog rules at their condominiums, and then everybody wants to have a dog and they say that it's a service animal. Condominium always wants to fight that and say we don't believe them. We don't think it's really a service animal. They're going to go to the Mass Commission Against Discrimination, and they're going to file a suit and say that you denied them a reasonable accommodation of having a service dog. It is not worth the time, the expense, and the angst, because you will be involved. You will have to be involved in the process of telling that person no. Now, there are certain things you are entitled to. You are entitled to request a doctor's note asking why they need an accommodation and how this accommodation is going to help them. But I can tell you almost universally this is going to be allowed. And if a complaint's filed at the MCAD and you didn't let somebody have a service dog, even if you don't believe them, they're going to find against you. So these are the things where you may not want to die on that hill. You might want to think about it and say, is this really the best use of our money? Which brings me to another point. If you are being sued by a unit owner or a developer or anybody, well, in particular a unit owner, you cannot charge the attorney's fees for defending to the unit owner's account. You cannot do that. That has happened many times where we're in the middle of a case and the unit owners then amend their complaint and say they're being charged fraudulent fees. And I look and yes, they're being charged for the attorney's fees. And I'm told by the property managers, well, we just automatically do that when there's a lawsuit. Make sure that's not happening. In the case that I had that was being handled, we ended up having to refund the unit owner who was suing us, give him back his money. And a case that was otherwise perfectly defensible would have definitely been kicked out on summary judgment because the person had no case. Because of this mistake, it raises a question of fact, and the case is now in a situation where we might have to settle it when it could have just been dismissed. So you want to be very careful about that. And on the enforcement cases, when you're enforcing rules, yes, all of the people here who do enforcement cases for you all, who say, well, you're entitled to get your fees back. Yes, the statute says that you can recover reasonable fees, for having to bring an action to enforce the rules and regulation of your condominium. That's true. But whether the fees are reasonable and if they will be awarded is decided by a judge. So you may not get them all back. You're entitled to get reasonable fees, but a judge determines what's reasonable. And if a judge doesn't award you the fees, then you don't get them. So it's not automatic. And I have found that a lot of board members in particular are not aware of that. They think that they automatically get their fees for bringing enforcement actions. So you are certainly entitled to them under the statute, and usually the condo documents say that you're entitled to them. But it's ultimately up to a judge. Insurance. If you are sued by a unit owner, you may have insurance defense coverage. Usually it comes under a D&O policy, which is directors and officers policy. So you may be able to be defended under that policy. One thing that I wanted to bring to your attention is the insurance companies usually want to defend under a reservation of rights. And what that means is that they are agreeing to defend you, but they're reserving their right to come back at a later date and say, you know, this really doesn't fall under our policy and we don't have to defend you, or we're not going to cover the judgment on this because it doesn't fall under our policy. So sometimes they decide that they're going to defend, and then at a later date, they change their coverage position. I had that recently in a case where an insurance company changed their coverage position. We are 3 months before trial, and the association lost their insurance. So that's another issue that has to be taken into account. It's not automatic that you're going to get insurance coverage, and those are issues that we can certainly help you with. That's not anything that you have to decide, but I wanted to raise it because when you're deciding whether you should bring a lawsuit or if you get sued, or if you take actions that could cause you to get sued, you need to know that just because you have insurance doesn't mean that you're going to have coverage for whatever the claim is. So the other issue with reservations of rights and the insurance companies is we at MEEB are typically your general counsel. We only do condominium work, and we've been doing it for a long time. Many times we are familiar with the underlying facts of a particular case. Most of our clients want us to defend them in a lawsuit. Insurance companies would prefer to send the case to what they call panel counsel. Most of the insurance companies have agreements with various law firms to take cases at half the rate, half the hourly rate, or even less than that. And so as a result, they want to take the case from us and they want to reassign it to somebody else. These other defense lawyers, they're certainly competent, but many of them are not familiar with condominium law. This doesn't mean you're not going to get a good defense because they have to get up to speed. However, as I said, it's usually far more efficient for us to keep the case because we know the underlying facts, we're familiar with condominium law, and we've already been representing you. So what you should know about that is if an insurance company says that they are defending a case under reservation of rights, you have a right to pick counsel of your choosing. The insurance company does not have a right to reassign the case if you don't want it reassigned. The only way that they can do that is if they agree that they're going to defend you without any reservations. If they agree to do that, that is very good for you. That is very good for the associations, because that means that no matter what happens, if there's a judgment, if you lose the case and there's a judgment, they're going to pay it. They're going to pay all your defense costs, and they can't come back and say, we're not covering this. So you might have to get a new lawyer, but they're going to cover everything. So it's not all bad. But if they say we're only going to do this under a reservation and they're trying to hedge their bets, then Massachusetts law says that you have a right to counsel of your choosing. So whenever I get a new case, I explain this to the clients. It is a little confusing. We can certainly help you navigate all of these insurance issues, but you should be aware of that concept because they will usually try to take the case and assign it to panel counsel. Just one other well, on the topic of legal fees, you are entitled to legal fees on collection matters. So I don't mean to say that you're not entitled to those fees, but you are certainly entitled to fees when we have to bring an action for collection. So the next issue is, how far should you pursue an enforcement action or a collection action? And I have another example. One of our clients wanted to bring a collection action, which you have to, as trustees, you have to do. It's your obligation to collect the common area fees. But they brought a collection action against a woman who was complaining that, the fees weren't appropriate and all of that. She was in the wrong. We got an order, foreclosed on her unit, and still to this was, I think we foreclosed on her unit in 2020. Still today, she's filing appeals. The appeals are not covered by insurance. They're all part of the same original action, and the association was the plaintiff. So there's no insurance coverage. And the action to collect a few $1,000s in fees has now cost that association $50,000 or $60,000 by defending her frivolous appeals. You can't ignore the appeals. They have to be defended, because if we don't defend them, the court could enter a ruling and say, well, they didn't oppose it, they didn't show up. So we have to defend it. But that association is faced with a lot of money in attorney's fees compared to what they collected in a collection action. So I guess my point on this front is, if somebody needs more time, maybe you give them more time. Try to talk to people, try to make deals if you can, because it's not worth litigation is difficult, and it's not always worth filing a suit against these people when they can come back, and even though it's frivolous, file frivolous actions and end up costing you more money than what you were trying to get in the first place. Now, that case is not the norm by any stretch of the imagination, but that is a case that I am currently handling that is out there. Another one that we have is started out as there was a flood, and the unit owner is disputing whether he's responsible for the damages in his unit. The trustees and the property manager did what they were supposed to do, but the unit owner counterclaimed, and that case is costing the association huge amounts of money. There's no insurance. So I would say, because it wasn't my case in the beginning, I would say I would have told the association, maybe try to talk to him. You don't have to do this. You don't have to pay for the damages in his unit, but maybe have a conversation at least. Don't just say, no, that's your responsibility. Maybe at least have a conversation with the person. There was no conversation. There was no discussion. It was just no, 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 and the person sued them. So again, I'm advocating common sense. I'm not suggesting that any of the clients did anything wrong in any of these examples because they didn't. But what I'm suggesting is that, cooler heads have to prevail. Stop and think. Use common sense and ask questions, have conversations. Try not to ramp things up. And I know that it's difficult, but that's really the point of most of the examples that I'm giving you. Be judicious in your rule enforcement. We have a client who has a trustee who has, I'm sure all the other trustees are happy about it, but she's taken it upon herself to be the rule violation police. She takes pictures, she walks around the property every day, she takes pictures, and she issues rule violations every single day. One such violation was issued to a woman who was a new resident who had a disabled daughter whose only means of transportation was bicycle. There was no room in the bicycle storage for this person's bicycle. She was put on a waiting list. And she chained her bike to a tree. She put her bike on the deck. Every time she put her bike in a different place, a violation notice was issued. The woman was pleading, where do I keep it? Because she needs this for transportation. She's disabled. Basically, the upshot of it was that it wasn't the condo trust problem, and she needs to keep the bike in her unit, which she didn't, she said she couldn't do. My point in telling you this story is the woman, by saying that she had a disabled daughter that needed the bike as a means for transportation, even though she didn't use the words, that is requesting a reasonable accommodation for her disabled daughter. That woman has since sued. She actually didn't sue for disability discrimination. She sued for something else. But I suspect the case will be converted by the Mass Commission Against Discrimination to a disability discrimination case. The first thing that crossed my mind was, why didn't they buy a bicycle rack? Cost a couple $100. Buy a bike rack so that the lady can park her daughter's bike in a bike rack, put it wherever you want to put it in the common area. But these are the kinds of things that I'm suggesting you think about when you're enforcing the rules. What will it cost to put in another bike rack or even another bike shed? What would that cost versus getting sued? Because when you get sued and you have a lawsuit pending, it becomes difficult for people to sell their units. Banks want to know if there's any litigation. They ask me what the litigation is about. We explain to them, and they may or may not want to fund a loan for a potential buyer if there's litigation pending. And when litigation's going on, depending on whether it's at the MCAD or in the state courts, it can last upwards of 7 years. So typically discrimination cases are not an issue when somebody wants to buy or sell a unit, but certainly construction defect cases are. No bank wants to fund money if an association is suing a developer for construction defects. So that's another thing that has to be thought about. And I'm, if there's a construction defect and you have to do something about it and you have to sue the developer, you may not be able to do anything about that, but it's something that needs to be discussed. You need to talk about before you decide to spend the money on litigation. Um, on the topic of discrimination, the Mass Commission Against Discrimination has a class called Housing Discrimination 101. I believe it's just a half day. It costs $250 for up to 6 people to go to it. And I would recommend that every property manager and every person sitting on a board attend this training. I get a discrimination case either once a week or once every other week. So I get I would say I get 3 to 5 cases a month. They cost money. There's not always insurance. They take time and they cause problems in the community. So it is worth sending. If you have a large board, send just a few people. But it's certainly worth it so that you can recognize, even if somebody doesn't use the proper language, like the lady saying her daughter needs a bicycle and she's disabled. She's not saying I need a reasonable accommodation, which is the triggering language, but she's saying my daughter needs her bike, which is essentially saying the same thing. This class will help you recognize when somebody has a problem, when they have a disability, when they need help, when they're asking for help. It'll help in the long run. For $250. It will save you money in increased insurance premiums and money that you may potentially have to pay in settlement or a judgment if you were to lose a case for discrimination in housing. So it's really a good idea to attend that. And you can, I believe they do it online by Zoom. You can go onto the MCAD's website and you can register for the classes and see what they're all about on their website. So now let's suppose that you have decided to file suit or you have been sued. What's the next thing that you do after you send us the complaint? You should prepare a chronology, because as I said, sometimes these cases take years. Sometimes issues have been going on for some time before suit is filed. You should prepare a chronology of events as best you can. Nobody likes to do it. Nobody wants to take the time to do it, but it does save you time and money in the long run. Number one, I will always ask you for a chronology if you send me a case. I want to know what happened and when it happened. And I need that either to file a response to the lawsuit or to draft your complaint if you want to sue somebody. I need the facts, and they have to be as accurate as possible. So that's the first thing I'm going to ask for. So if you all think that you want to bring a lawsuit, you should think about that you need to prepare a chronology. This will come in handy down the road when we have to do discovery, answer interrogatories. If you're going to be deposed, then you can always refer back to your chronology, and you won't have to worry as much about remembering something that happened 4 years previously, because you have it in your chronology, which you prepared at the time that the facts were fresh in your mind. You should also immediately, upon deciding to sue or upon receiving a lawsuit, you should save whatever relevant documents you have. Create a separate folder in your email or on your computer and save any documents that are relevant to the case in this folder. And if you have email communications with us or with any other lawyer, you need to save those in a separate file marked attorney-client privilege, so that those emails do not inadvertently get disclosed to the other side in the process of doing discovery. So start saving your documents. It's required by law that you preserve all documents. If there's anything of concern that you come across in your documents, like let's suppose there's a document of a trustee calling the person that sued them names or something like this. You want to highlight that and bring it to my attention so that we can defend and do something about that. Any bad information, anything that you're embarrassed about, those are the things that you want to highlight and bring to your attorney's attention as soon as possible, because we're here to help you. We may scold you a little bit, but we're here to help you, and we, in order to defend you, we need to know everything. On the subject of attorney-client privilege, our client is the trust, the condominium trust. The board members are the representatives. So any communications with any board members and your property manager as your agent in our office, all those communications are protected by attorney-client privilege. Those communications will not be disclosed to anybody else unless you're the ones disclosing them, but we will not disclose those communications. Can lose our license if we do that. So remember that, because if you inadvertently, let's suppose we have a Zoom call to talk about litigation, and the wife is on the board and the husband is not on the board, but the husband's in the room while we're talking about litigation, that could be considered not an attorney-client privileged discussion because somebody who's not on the board was in the room. So be mindful of that. I will always try to remind people, make sure that there's nobody else in the room when we're having a privileged conversation. But you also need to remember that when you're having board meetings, you don't want to discuss litigation with unit owners in general. So when you have an annual meeting, everybody always wants to know about the litigation. You cannot answer any questions about the litigation. Typically, we will get a call from the property manager and ask us to attend the meeting. I will say where the case is in the process of the litigation, but I will not disclose any facts or any strategy or anything else about the case, because that violates attorney-client privilege and it could damage our strategy with our case. So do not discuss litigation with other unit owners. Even if they were former trustees, if they're not currently a trustee, you can't talk about it with them. So be mindful of that. Many times I have had trustees say, oh, I discussed this with the former trustee because that person was aware of some of the facts. Sometimes that has to happen. Sometimes there has to be discussion, but simply about facts, not about strategy and what's happening in the lawsuit. So if there's ever a question as to whether you should talk to somebody, your first call should be to us so that we can help you with that and answer your questions. Another best practice is not to put everything in one email string. Email strings are a problem. If you end up getting sued, they become problematic because you may be having a discussion in one email with a unit owner, then you forward it to your fellow board members, and then all the board members start responding, and then the property manager sends it to counsel, and then I'm responding, and then somehow it ends up getting back to the unit owner, or somehow a privileged communication is revealed. When we have to produce email strings in discovery, we frequently have to go through a 10-page email string, redact anything that's privileged, which means cover it up, take it out so that we're not disclosing it, and And sometimes there are problematic communications mixed in an email string. The better practice is always, if you have a new subject to discuss, make a new email. Emails with counsel, don't turn those into email strings. Keep them separate. There are always going to be some email strings, but try to minimize the length of them by creating new subjects. Another best practice is do not text. This is mostly for the property managers, but do not conduct business in text messages. If litigation becomes an issue and all of your communications are in text messages, the record becomes very convoluted and difficult because you don't always know. The name isn't always at the top of the text. The time and the date isn't always on the text. Trying to piece together pieces of text messages when they're printed to reflect the record in your case is extraordinarily difficult. And frankly, it's just unprofessional to be conducting business by text message. You should always be using email. It keeps a more accurate record. It's more clear. The property managers will have their business information on there. So don't use text messages. I think every litigator in the firm would tell you not to use text messages. Another thing that I'm going to start requiring, because I now have my third case where this has become an issue. Because of the nature of your business, your condominium and the property managers, there's a lot of turnover of board members. You're up for election or you get replaced with some regularity, and property managers change over time. Because litigation cases, depending on the case, can take years. It could be that you have turned over board members multiple times in the space of a single piece of litigation going on, and property managers. So I've had one case, was a great case. We were defending. There were no problems with the case. I was going to dispose of it. And without my knowledge, the property manager was terminated. I mean, rightly so. I guess she wasn't doing her job, but she was the only person who knew the facts of the case. The trustees didn't know anything. The new property manager didn't know anything. The property manager supervisor didn't know anything. The only person who knew anything about the litigation was terminated, and I was left with a trial date with no witnesses at all to put the case forward. A case that I don't like to use the word slam dunk, but it was a slam dunk. So that happened. I had another one, almost the same thing. Property manager retired. She's the only person who knew anything about the case. And nobody told me for 6 months about both of these, by the way. So when I found out that she retired, I said, well, who's left on the board? Nobody was left on the board. The entire board had been replaced. We have to answer interrogatories, and none of the board members know anything about the case. The new property manager doesn't know anything about the case. And once again, on a case that is easily defensible and should be won, I have no witnesses. On a construction defect case, I had a property manager who got sick. She doesn't work there anymore. The board has been completely replaced. She was the only person who knew where all the defects were. So what I'm going to start asking you all to do is, at least 3 trustees need to be involved whenever there's litigation. And I know all the boards are different sizes. You can decide however many people you want to have, but I'm going to say at least 3, because the odds of all 3 getting replaced are slimmer than if it's only one person. And you cannot abdicate a piece of litigation to your property manager, because if your property manager gets replaced and board members don't know anything about the case, you're not going to have any witnesses, and you can lose simply because you don't have any witnesses. So I'm going to ask the property managers to keep their supervisors informed about the details of the litigation. I'm going to ask the trustees to have multiple trustees involved to minimize the chances of having no witnesses. But we can talk about that on a case-by-case basis as they come in. But I'm going to suggest to you that you all implement that right away. Another thing is don't try not to make things personal if you get sued. And you may be named personally in the case. That doesn't mean that you're going to be individually liable. There's language in your condominium documents to protect the trustees. You are indemnified for any actions that you take in the course of your duties as trustees. So you'll be indemnified, and property managers are also indemnified. So, but you may be named personally. Try not to take things personally, and try not to let that affect your behavior when you're conducting business for the condominium trust. Because at the end of the day, a lawsuit is the business of the condo trust. So try not to take it personally. I have had issues where parties in a case have taken things very personally and had ramped up email arguments with the party suing them, which have only complicated the litigation, and it's unnecessary, and it shouldn't be happening. You have to always remember, going back to the beginning of this talk, you have to always remember you have a fiduciary duty to the trust. So try not to take things personally. And again, don't talk to the person who's suing you, if at all possible. And lastly, if you have any questions about anything related to litigation, call us. We're here, we work for you. We can answer your questions. We can help you decide if you want to sue somebody. We can help you decide how to defend the case. We'll help you with insurance issues. We're here for all of you. So don't be afraid to ask us questions if you're trying to make decisions about whether you should or should not sue somebody. So that is it for me. I see there are a whole bunch of questions. Let me see. Okay, somebody says, please discuss conflict of interest between insurer control of panel assigned counsel and insured chosen counsel. I don't know that I understand the question exactly, but there should not be any conflict of interest. So when we represent clients, when the insurance is covering under a reservation of rights, our duty is first to you all as the client. We are not obligated to follow insurance guidelines. We don't have to fill out their reports. We don't have to cut our rates. We don't have to do all of the things the insurance company wants us to do. Now with panel counsel, you are still panel counsel's client. They have a duty to you as their attorney, but they also, the insurance companies can require them to report to them. So they have to also take some direction and report to the insurance company, because the insurance company is footing the bill and covering any damages. So it's not a conflict of interest. It's just a little bit different obligation as to whose rules we have to follow, so to speak. Let's see. Can a board sue in order to use and pay for their vendor instead of using the vendor the board wants them to use? Some of these questions are very specific to your individual condominiums, and I wouldn't be able to answer these questions without looking at the condominium documents. So, there's a question here about vendors using the vendor of the board. I can't answer that question without looking at the condominium documents, but if you want to send us an email, we can certainly answer your question after we look at your documents. On the foreclosure action, I described the association auctioned the unit. The appeal came too late, which were the grounds for dismissing the appeal and the reason that the person has been unsuccessful. The court has declared the person to be a vexatious litigant, which means that they don't do anything with her documents anymore. If a problem is unresolved and the association is sued, will the merit of the case be affected if it can be shown that the unit owner was never allowed to address the issue during a board meeting? I mean, every case is fact specific. Again, this is a pretty fact specific question. It depends on what the discussion was and what the question was. People don't always have a right to address their issues in a board meeting. But I would say if the issue comes up and you have questions, you should ask us if you should allow the board, allow the unit owner to speak, or if you should answer their questions. I mean, if you have any question at all about how to handle a unit owner or a problem that's come up, you should call us and we can help you. There's a New Hampshire question that I am not licensed in New Hampshire, so you're not doing audits on our mission. Yeah, I don't know the answer to this New Hampshire question. Can you include in the chat or email out information on this housing discrimination class? I can tell you, if you put into Google MCAD housing discrimination class, it will probably be the first thing that pops up for you. That's how I did it this morning when I was looking for the price, so that I could tell you what the price was. Should you also track the costs along with the chronology? Yes, depending on what kind of case it is. If you're defending a case, then no. If you are suing, for example, if it's a construction defect case and you have to keep making repairs because of construction defects, then yes, you need to be keeping track of costs and the dates and the invoices. Clarify about indemnified for board members, agents. What is there, and what if there is malice or intentional act? Yeah, so on indemnification, if a trustee, for example, when indemnification would not apply is if a trustee acts outside of their duties to the condominium trust, outside of their duties as a board representative. So if for example a trustee were to discriminate, blatantly discriminate against a unit owner, it would have to be very blatant and severe and outside the scope of what they are doing as a board member. Then you may not be indemnified. You are indemnified for acts that you take as representatives of the Board of Trustees. You're not indemnified for going off the reservation and taking matters into your own hands and acting outside of the scope of your duties as trustees. I cannot recommend a fair housing education source in New Hampshire because I'm not licensed there, but we have counsel in New Hampshire and we can certainly get back to you. If you want to send me an email, I will get the answer to that question for you. Does a condo association have a right to indicate the weight and size of a dog? Not if somebody's asking for a service animal, you don't. A person's going to be allowed to have whatever service dog they deem necessary. You can't dictate the size of the dog. So can you indicate the weight and size of a dog absent any kind of request for an accommodation or any other kind of discrimination? Then yes, but not in the context of discrimination. Does the board have a responsibility to require unit owners to pull permits when doing electric work and plumbing work? I mean, that is usually in your condominium documents that unit owners have to use licensed professionals who pull permits. So that depends on what your condominium documents say. What if unit owner takes the board to small claims court? Is this litigation? Yes, it is litigation. And how do you respond to it? You call us and we will tell you how to respond to it. Every case is specific and different, and how you respond to them depends on the facts of the case. I don't know somebody said you mentioned the association's right to select its own attorney under Massachusetts law. Does this also apply under Rhode Island law? I don't know. I'm not licensed in Rhode Island. I suspect it is the same, and I can certainly get you that information if you want to send me an email. On the statement of HOA cannot charge unit owner attorney's fees, you said that is for Mass and not allowed. What about Maine? Let me just clarify that I said that is when you are sued by a unit owner. You cannot charge the attorney's fees. I am, again, not licensed in Maine, but I would suspect that is the case in any state. If you get sued for something, you can't charge those fees to the unit. How do you handle cases where you have both the condominium and the management company as clients? So when I have the condominium and the management company as clients, there's no conflict because the property manager is your agent. And because they are your agent and acting at your direction and under your control, there is no conflict. If there ever should arise a conflict between a management company and a condominium association, we would actually have to withdraw from the case because that would present a conflict for us and you would each have to get new counsel. But that has never happened since I started working here. I've been here I think 5 years. That doesn't typically happen because all your interests are aligned because they are acting at your behest, which is why I said in the beginning of this talk, you need to make sure that you're directing your property manager, and not the other way around. What do you do if he, okay, some of these questions are really specific about situations that are happening in your condominiums, and I cannot answer them in this forum. But you can email us and we can get people to help you. There's a question about a hoarder. I can't answer that right now. Every case is different and specific, and those are more appropriately dealt with directly with the condominium and the right attorney here who can answer your questions. Can the association recover legal fees in construction defect cases if the board wins? No, not usually, unless there's a clause in a contract somewhere where you're entitled to contractual damages. You don't get attorney's fees. Okay, I think that's about all of the questions that I can answer in this forum, as I said. If you have specific questions and you want to send me an email, my email address is dmcdonald@meeb.com. Or if you have general counsel that you typically deal with here at the firm, you can email them directly. Some of these questions are general in nature, and I am a litigator, so I'm the one who you don't ever want to talk to because I'm the one who defends you if you're in the middle of a lawsuit or prosecutes a lawsuit for you. So anyway, I hope that this was helpful and informative, and I wish you all luck with all of your litigation. Thank you and have a great day.